Hello everyone, and thank you for coming to this very interesting lecture by Dr. Tendayi, and I want to pronounce your last name correctly, so I prefer that you do it.
I was going to make you say it. Achiume.
Achiume, there you go. This is the first time we have a lawyer among us who is going to talk about the responsibility to protect refugees. As you know, the Syrian refugee crisis, the protracted Palestinian refugee crisis has afflicted Lebanon and a number of other countries in the region. We often forget, based on all of these ideas of aid and development, the true essence of what should be done, which is protecting these refugees themselves. Tendayi is assistant professor of law at the UCLA School of Law. Her research and teaching interests fall exactly where this presentation is, which is international human rights law, international refugee law, comparative immigration law, and international criminal justice. She earned her BA from Yale and her JD also from Yale Law School. She's also earned a graduate certificate in development studies, again from Yale. She clerked for the Deputy Chief of Justice in the Constitutional Court of South Africa. Following these clerkships, she was awarded the prestigious Bernstein International Human Rights Fellowship to work at the Refugee and Migrants Rights Project Unit at the Lawyers for Human Rights in Johannesburg. She has also taught on the faculty of the International Human Rights Exchange Program based at the University of Witwatersrand, and then she joined the New York office of Sullivan and Cromwell as a litigation associate. So we're going to get a really law-based perspective on this issue today, which is going to be fantastic. Immediately prior to her current appointment as Assistant Professor of Law at Yale, she was the second recipient of the Binder Teaching Fellowship at the UCLA School of Law. She's traveled all the way from the West Coast, and we'd like to thank you very much for being here. Thank you.
Thank you so much, Rima, and I feel like I should be thanking you all for being in this room. As Rima mentioned, my research and teaching interests focus on international refugee law, international human rights law, and I want to get a sense for how many people in the room have a legal background. Other than Fatah. Okay, good. So it's just the three of us. This is excellent. I really enjoy giving these kinds of presentations to non-lawyers because I think often the most exciting work happening around protection, refugee protection work, is not actually being done by lawyers, even though lawyers are doing a lot. So what I thought I would do is give you a little bit of a roadmap of my presentation. I plan on speaking for about 30 to 45 minutes, and remember, you need to cut me off at 45 minutes because I'm really interested in Q&A and comments as well. And what I'll do is I'll begin with a little bit of background on the project and how I came to work on this, and then I'll talk a little bit about how I see one of the key problems at the center of the refugee crisis to be, and then I get to my proposal. And then in conclusion, I'll briefly reflect on what I think are some key challenges to the proposal that I'm making. And then when I open it up to Q&A, I'll expand on anything that you happen to find interesting. The presentation that I'm making today is actually based on a paper that is under review for publication. So it's still a work in progress. I'm still thinking through some of the issues that I'm going to be talking about. So your feedback is actually very, very welcome at this stage. So I thought I would start with just a definition. The term refugee is used in lots of different contexts and to mean lots of different things. As an international lawyer, I'm relying here on the international refugee law definition, which is a refugee is a person who, owing to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group, or political opinion, is outside their country of nationality, and is unable or unwilling, due to this fear, to return to their country of origin. So the thesis of my paper, of the project that I'm working on now, is about international cooperation among states to protect refugees, and really it's about sharing the cost and responsibility of protecting refugees. And states are at the center of my analysis, but really my project is driven by a concern for individuals, and my background is actually in the rights of individual refugees, and so that's the unit of analysis, if you can call it that, in most of my work, but in this project I'm going to be focusing on state cooperation. prior to working on this project, I was doing research on xenophobic discrimination against refugees and was focusing on the case study of South Africa, which up until 2011 or 2012 received the highest number of individual asylum seeker applications. So asylum seekers are, as a legal matter, are people who say they're refugees but whose claims actually haven't been determined by any state and been confirmed. So in South Africa, you have a high number of individual asylum seekers, and you have a persisting problem of xenophobia, where xenophobia is just discrimination on the basis of one's status as a foreigner. And in doing that research, what became very evident is that often a lot of what fuels tension between refugees and host communities is actually actual and perceived sense of resource scarcity, right? So refugees and asylum seekers often exist in contexts or are living in contexts in their host communities where the people at the lowest socioeconomic levels in that society, in that host community, are the ones who are most severely impacted by refugees. And so tensions often come out of these structural conditions of inequality, of poverty, different sorts of things. So in doing that research, what became clear is that if we're interested in the protection of refugees in any domestic context, the question of resources is going to be a huge one. And often the resources that are required to protect refugees are beyond the means of whatever community is actually hosting those refugees, whatever country it is. And so just to give you a sense of what the global picture is like, and I feel fortunate to be in a context where people actually understand what this problem looks like. They're living it, they're experiencing it. In many ways, you all could be giving me a lecture about this. But in many of the places where I give these lectures, like in the United States, for example, there's misconceptions about where it is that refugees are concentrated in the world. So most people, at least in the global north, imagine that that's where most refugees are. Refugees are kind of running away from the global south and flooding the global north, and that's where they're concentrated. But that's completely untrue. And as I mentioned, I'm sure you all are very kind of alive to that reality. So in 2013, the UN Refugee Agency put out the statistic that developing countries hosted 86% of the world's refugees. And this wasn't an anomaly in this particular year. This is a statistic that is reflected over a long period of time. I don't know if you all can see the slide, but basically it's a slide that tracks who's hosting refugees between 1989 and 2013, and the blue part of that bar is the percentage of refugees that are hosted by developing countries, and then the green part is developed regions. So what you can see is over this long period of time, states in the global south or developing countries, you want to call them that, have hosted a disproportionate share of the global refugee population. And an important point to make is that there's no principled basis for this distribution of refugees globally, right? And what's driving the current distribution is just geographic proximity to conflict and also porousness of borders. These are the two factors that determine where it is that refugees are concentrated. And a situation like the Syrian refugee crisis really illustrates this point very, very vividly. As you all are aware, according to the UN Refugee Agency, there's approximately 3.9 million Syrian refugees. Most of them are concentrated in Turkey, Lebanon, Jordan, Iraq, Egypt. Again, usually when I'm presenting elsewhere, I really have to go into what this really means, but because I'm in Lebanon, you all, again, know so much about this. In contrast to the concentration of refugees in the region, you look at a place like Europe, which according to the UN Refugee Agency, again, by December 2014, had extended protection to only 217,000 refugees. So if you think about Europe, which is dramatically larger than a country like Lebanon, they've taken in 217,000 refugees. Lebanon has over 1 million. So this is just a disproportionate skew of where the refugees are concentrated, and tied to that is a disproportionate bearing of the cost and responsibility of protecting these refugees. I'm going to talk a little bit about how international law interacts with this particular distribution, but before doing so, I just want to highlight that the effects of this, what I'm calling in my research, maldistribution of refugees, are detrimental for a whole host of reasons and for a whole host of actors. So for the refugees themselves, as you all are aware, having them concentrated in regions that don't have the resources to extend the necessary protection means that access to very basic needs like food, shelter, education are tenuous at best. It also raises the likelihood and existence of international human rights violations, sexual exploitation, child labor, all kinds of human rights violations. Separate from the refugees, their host communities also are impacted in a very intense way by this distribution of the refugees. So due to the demographic pressures, you have reports of increased rental prices, depressed wages, increased pressure on public services, and conditions that are just not sustainable for the refugees and for their hosts, and that result in really troubling conditions on both sides. So there's a lot of problems that are implicated by the Syrian refugee crisis, and a lot of drivers to the existing problem. What I focus on, and by focusing on this, it's not to ignore the broader context, but it's kind of to narrow down on the one piece that I take on, is that at least one piece of the puzzle in alleviating the crisis is improving international cooperation to share the cost and responsibility of protecting refugees. And in the case that I focus on in my paper, it would be Syrian refugees. So if you look at the UN's big effort to raise funding to protect Syrian refugees, the current figure that they have, I think, is about 3.7 billion US dollars, and the funding, the percentage of that they've actually been able to secure has hovered over the last 3 years between about 40 and 61%. It's severely underfunded. And so one way in which the conditions facing refugees and their hosts as well might be alleviated if there was more assistance from the international community. And so the question at the core of my research is really looking at what mechanisms or what means do we have for improving or facilitating international cooperation to protect refugees. Also, I realize I speak really fast, so if I'm speaking too fast for anyone in the room, just raise your hand and I'll slow down. Who thinks it's going too fast? Okay, no, so, okay, it's not a concern to be worried about. Okay, one, okay, great, I don't feel crazy. My students always tell me I speak too fast, so I'm going to try and slow it down.
We have time. Okay.
Time. Great. Usually I'm only given 15 minutes, so I have to cram it all in, but here we have 45, so this is going to be good. So as I was saying, one of the key challenges, I think, is increasing international cooperation to protect refugees. And at least in popular conceptions, one of the concerns, or one of the reasons that exist, at least in the context where I'm coming from, people think, well, one of the challenges to international cooperation to protect refugees is that the resources just aren't available. So perhaps countries outside of the region just don't have the funds to be able to protect refugees, and that's actually not the case. It's not that we're not seeing international cooperation because money isn't available. The problem lies elsewhere. And in 2013, the UN High Commissioner for Refugees made a statement that I think really drives this point home vividly. So in 2013, he said at that time that the money that was required to provide protection to Syrian refugees was the equivalent to what Americans spend on ice cream in 32 days, what Australians spend in overseas travel in 32 weeks, and what German drivers spend on petrol in 6 weeks. So we're not talking about huge amounts of money relative to what's being spent on other things. If you think about NATO's intervention in Libya, the amount of money that the US was spending on a daily basis was astronomical compared to what it would require to address the Syrian refugee crisis. So this isn't really just about money, which I think in many people's minds that's what it is. There's just not enough resources out there. And so I put up that quote because I think it really drives home this point that something else is going on. So even though I'm an international lawyer, in thinking through this problem, I've been looking at the work that international relations scholars have been doing to try and make sense of international cooperation to protect refugees. And there's a scholar at Oxford called Alexander Betts who's done a lot of research on this particular question, and he, among others, have conceptualized refugee protection as a public good. And so they attribute this difficulty in facilitating international cooperation to the nature of refugee protection itself. And so one of the key problems is that the entire international community benefits even if a handful of individual states extends protection to refugees, and there's just no real incentives for states elsewhere to assist the states that are hosting refugees with protecting those refugees, because they will reap the benefits anyway. And so you have a situation where if 86% of the world's refugees are concentrated in the global south, the means that they have to pressure wealthy countries to assist with the protection of refugees are few and far between. So while there are many problems that are going to go into whether or not we have international cooperation to protect refugees, I think at least one missing piece in the puzzle is an international frame for facilitating this protection. So there's a rich interdisciplinary literature in sociology and psychology and political science that really supports this idea that frames play a really important role in influencing the attitudes and behaviors of states, and also of individuals, but also relations among states. And the definition of a frame that I use in my work is the one above. A frame is a way of selecting, organizing, interpreting, and making sense of a complex reality to provide guideposts for knowing, analyzing, persuading, and acting. So a frame isn't going to solve the entire problem, but it's definitely going to provide a context within which you can persuade state actors to behave in the ways that you want them to behave. And if you look at this question of international cooperation to share the cost of protecting refugees generally, even outside of the Syrian context, there is no, or at least there is no frame that people are using to have this conversation about how to achieve cooperation. So institutional regimes, you might think about the international refugee law regime as a frame that might be used to facilitate international cooperation to protect refugees. And so an underlying premise of my argument is that limited international cooperation to share the cost of refugees is at least in part a problem of framing. It's a framing issue. And from a legal perspective, if you look at international refugee law, it is part of the problem. It doesn't create a legal obligation on states to assist other states with the protection of refugees. So let me just step back and paint a picture of you of what the international refugee regime looks like. So international law is basically made up of different things, including treaties, which are agreements by states to be bound by the terms of that treaty to behave in certain ways and to fulfill certain obligations. And so with respect to international refugee law, which is the law that governs refugee-specific issues, you have two treaties that exist right now. You have the UN Refugee Convention relating to the status of refugees, which was adopted in 1951, and that was adopted by Western countries and following the Second World War to address the problem of refugees from the Second World War. And it was limited, it limited the definition of refugees or its application to refugees fleeing events in Europe that happened prior to 1951. In 1967, the international community adopted the protocol relating to the status of refugees, and the purpose of the second treaty was to remove the geographic and temporal restrictions that were imposed by the first one. And so now refugees didn't just have to be refugees who were fleeing events in Europe before 1951. It didn't matter where in the world you were fleeing or when the events took place, as long as they met the definition that I placed up earlier, they qualified for refugee status. So these two treaties, which really are coming out in a very specific historical moment, are the treaties that govern, these are what we refer to when we talk about the international refugee law regime. Now, what these two treaties do is they create obligations for states that have signed, that have ratified these treaties to protect refugees on their territories. So of the 5 countries that are hosting the highest number of refugees, Turkey and Egypt are the only ones who have ratified the UN Refugee Convention and its protocol. And Turkey has maintained the restrictions in terms of geography and the time period, but it has nonetheless ratified both of those treaties, and the other countries have not. But in any case, what these two treaties do is that they require states that are hosting refugees to protect those refugees, but they don't create a corresponding obligation the states beyond those states to assist in any kind of way. So for a country like Egypt, Egypt is required to protect Syrian refugees, but the Refugee Convention doesn't require Germany or the United States or Zambia to assist Egypt with the protection of refugees in the soil. So you have this asymmetry and this problem that's built into international refugee law itself that I argue is at least part of the problem of why we're not having international cooperation. And among lawyers, you know, there's this idea that if you have a law, you're halfway solving the problem. I think that's one that we can contest in many ways because the enforceability of international law is complicated. But even while acknowledging that, I think it is valuable to have these frames that can help us get states to behave in the ways that we want them to behave. So the point I make, and many other people have made this point, that international refugee law sort of sets us up for failure, and there's a long history and trajectory of international refugee scholars who've proposed different approaches to solving this problem, and even the UN Refugee Agency itself has talked in different ways about how the international refugee law regime, there's gaps in it with respect to dealing with the contemporary problems facing refugees. So it's not big news to anybody that international refugee law has many shortcomings, among which is this issue of being unable to facilitate international cooperation to protect refugees. And I agree that we need a complete overhaul. We need a comprehensive rethinking of what international refugee looks like. We likely need new treaties to think about the issues, to think about addressing the issues that the world faces right now. But this is a really long way off, and states have shown a reluctance, if anything, to renegotiate the terms of international refugee law. So while accepting that a comprehensive solution is required, one of the challenges that I take on in my work is looking at what tools we have in the international system that, pending this comprehensive review, we can use to facilitate international cooperation. So this is how it is that I turn to thinking about the responsibility to protect. I don't view it as a first prize or a best case scenario. I think the best case scenario is reform of the refugee regime, but in the absence of this best prize, I think there is an onus on scholars, on policymakers, on advocates to see what we can do with the tools that we have, given the high price that refugees and their hosts play in the absence of any kind of action. So the responsibility to protect, I'll start out by saying, is actually not binding international law at all. And in my paper I call it soft law, which means it's a set of principles that are supposed to guide, that states agree should guide their behavior, but there's no legal sanctions attached to not abiding by the responsibility to protect. So among lawyers, how they view the responsibility to protect often tracks how seriously they take soft law. There's some lawyers who, if it's not legally binding, they're not interested in it. And I happen to not fall in that camp. I think given how complex compliance and enforcement of international law is, focusing only on legally binding documents is, in my mind, missing half of the action that's going on. The responsibility to protect reconceives sovereignty as imposing a responsibility on sovereign states. And the articulation of the responsibility to protect, or R2P, that I use in my work is coming from the 2005 World Summit Outcome document. So in 2005, the UN General Assembly, which is a body that has all of the states that are members of the UN, they get a vote there. They unanimously agreed to adopt this doctrine of the responsibility to protect. And in R2P scholarship, and following a report that was issued by the UN Secretary General, there's 3 pillars that constitute the responsibility to protect. So the first pillar is the fundamental one, this idea that states have a responsibility to protect their territorial populations from war crimes, crimes against humanity, genocide, and ethnic cleansing. And I'm going to stress that it says territorial population. So it's not citizens, it includes anybody who's on your territory, it includes refugees, it includes internally displaced people, it includes unauthorized migrants, whatever you want to call them. They are included in this idea of who a state is required to protect under this doctrine. So that's the first pillar of R2P. Pillar 2 is the idea that even though states have this primary responsibility to protect populations in their territory, the international community has a complementary responsibility to provide international assistance, including capacity building assistance, to assist states that are unable to protect their populations from R2P crimes. And so the responsibility to protect any given territorial population primarily lies with the state, but where a state is unable or unwilling to provide that assistance, and for Pillar 2 it's usually that you're unable, not necessarily unwilling, because you need to be able to cooperate with the international community. The international community has this responsibility to assist. And then Pillar 3 is basically says that the international community also has a complementary responsibility to take timely and decisive collective action when states are manifestly failing to protect populations from R2P crimes. So under these conditions, it's more extreme than under Pillar 2. The idea is that action under Pillar 3 is more urgent and therefore may require more drastic measures than under Pillar 2. And the action as such that falls under Pillar 2 reflects that. So the action includes specific measures under Chapter 6 of the UN Charter. And on a case-by-case list where these peaceful measures fail, you can have coercive measures under Chapter 7 of the UN Charter. So Chapter 7 of the UN Charter basically allows the UN Security Council to authorize the use of force in certain situations to address international peace and security concerns. And this pillar of R2P has actually been the most controversial and the one that people talk the most about. And I'll talk more about that. So if you look at research and writing and even commentary on R2P, as I just mentioned, it really focuses on this Pillar 3 of R2P, and it focuses on analysis of whether the responsibility to protect has changed the way that states can use force against other states. And not just force in terms of military force, but also coercive measures like referrals to the International Criminal Court, sanctions, various measures that are considered to be coercive. And this commentary is not just from scholars, but even debates among states. So in the UN Security Council, for example, have really focused on this particular R2P, this particular pillar of R2P, which is the use of force. And similarly, so in doing so, there's been very little attention paid to what R2P might mean for the protection of refugees. And what I mean by that is, given R2P as it exists right now in the World Summit Outcome document, what implications does it have for the measures that states need to take to protect refugees? There hasn't really been much of that discussion among people who are talking about the responsibility to protect. And on the other side of that, refugee scholars as well haven't spent that much time really fleshing out how the responsibility to protect might be used to protect refugees. So the UN Refugee Agency has gone on record and actually stated that the responsibility to protect might be a useful doctrine for filling in the gaps in the international refugee regime. But there hasn't really been a public discourse about what that would look like and what it would mean to do so. And there's different reasons why this might be. If you're looking at refugee protection scholarship that focuses on international cooperation to share the cost of refugees, most of the writing was taking place prior to 2005, and I'm most familiar with American scholarship on the issue, and for some reason after 2005 there isn't that as much written. If you look at European scholars who are writing about this, many of them are focusing on the European system of burden sharing. There's some African scholars who are talking about the African system, but it just hasn't been much discussion since R2P came into international discourse about what role it might play in the protection of refugees. So that's one reason, I think, is just R2P is new, and so there hasn't been time necessarily to figure out what role it's going to play. The other thing is just R2P is a controversial doctrine, and the controversy around it really is around Pillar 3, and I'll talk a little bit more about that controversy in the end. And I think because in many ways people view R2P as a polarizing doctrine, there's been, I imagine, a reluctance among refugee scholars to associate refugee protection and cost sharing with the responsibility to protect. And one of the key things I'm arguing in my work is actually that's a mistake, and that there might be an opportunity here to use the responsibility to protect in different ways. And at this point, I should say that my engagement with R2P is in many ways instrumental. And what I mean by this is that I'm not ideologically invested in the responsibility to protect. I'm interested in what it can do, what potential it has for refugee protection and for the protection of vulnerable populations in general. And I think really that potential is yet to be seen. That's the position that I take it. It's not predetermined. And in figuring out whether we can use the responsibility to protect refugees, we learn more about whether this potential can actually be realized. So it's possible that, in 5 years I will be sitting before you talking about how the responsibility to protect failed as a basis for refugee protection. And if that's the case, then I'm in agreement with those scholars who argue that the responsibility to protect should be relegated from international relations and discourse in this area. But I think it's a little too soon to completely write it off, and this project really is about trying to figure out what potential it has for solving this really difficult problem. So what I spend a fair amount of time doing in my research is fleshing out what action the responsibility to protect would require of states based on the rationale of the doctrine. So the idea is that the goal of the responsibility to protect is to protect vulnerable populations from the 4 R2P crimes that were listed up there: war crimes, crimes against humanity, ethnic cleansing, and genocide. And so what I do is I lay out how R2P can serve as an institutional frame for protecting refugees and for sharing the cost of protecting these refugees who are fleeing those 4 R2P crimes. So already at the outset, there's a limit on what the responsibility to protect can do for refugees, because not all refugees are fleeing those 4 crimes. There's refugees who flee all kinds of persecution that are not war crimes, genocide, crimes against humanity. But at least, for example, for the Syrian refugee crisis, there's a very strong argument to be made that every single Syrian who is fleeing Syria is actually covered by the responsibility to protect, because there's agreement among UN bodies, for example, that R2P crimes have taken place and may continue to take place in Syria. So with respect to Syrian refugees, this isn't a concern. It applies to all of them, but there's going to be many refugee populations in the world that fall outside of the scope of my proposal. Now, to understand a little bit the way that R2P is used in international discourse, I think the Syrian refugee crisis and the Syrian crisis in general is a good lens for seeing how things have played out. So, since the crisis in Syria began, any talk of R2P has focused on the responsibility to protect Syrians who are still in Syria. And the focus has really been on a conversation around coercive measures again, and these coercive measures have included sanctions. There's been calls for sanctions against various parties within Syria, International Criminal Court referrals. So Syria isn't a signatory to the Rome Statute, which establishes the International Criminal Court, but the UN Security Council can refer cases or situations to the International Criminal Court, and there's been countries and also just UN actors that have recommended and called for the referral of the Syrian crisis to the International Criminal Court to investigate crimes that are going on there as a way to put pressure on the regime, on the Assad regime, to put an end to human rights violations. And then there's also been countries and different actors that have called for military intervention, foreign military intervention into Syria on behalf of Syrians to put an end to human rights violations. So the discourse is really focused around that, so coercive measures focusing on Syria. And in the paper, which if anyone, by the way, is interested in reading the paper, I'm happy to email it to you. So afterwards I'll give you my email address and I'm happy to send it to you so that you can take a look at it. I track UN Security Council debates and statements made by various actors like the UN Office of High Commissioner of Human Rights, the UN Special Representative on the Responsibility to Protect, and it's in looking at these documents that you get this picture emerging where really R2P has focused on Syria and on coercive measures. And scholars are doing a similar thing. I focus primarily on legal scholars who are not analyzing these issues, but I think the same is true, say, for political scientists who consider the responsibility to protect with respect to Syria. And so what you see happening here is it's almost as though the Syrian borders are acting as an on-off switch for beneficiary status of the international community's responsibility to protect. And what I mean by this is when a Syrian flees Syria, right, so let's say she walks across the border from Syria into Lebanon, the way that the conversation around responsibility to protect has been cast is you would think that that's the end of the international community's responsibility to that individual because she is now in Lebanon. And what I argue in the paper is that that's actually not the case. The international community's responsibility to protect a Syrian refugee persists even once she's crossed that border, because the responsibility to protect is about protecting vulnerable populations. And for as long as that refugee remains vulnerable to R2P crimes, the international community has a responsibility to offer some kind of protection. Now, obviously, because the Syrian refugee is now in Lebanon, Lebanon too does have a responsibility to protect that refugee. But that doesn't sever the responsibilities of the international community. And what I argue is that instead, the responsibilities that the international community owes become a function of the host state's capacity to protect the refugees. So if you take a country like Sweden, for example, which is among the European countries that have taken the largest number of Syrian refugees, to date, Sweden has not expressed an incapacity to protect the Syrian refugees that are there. And so, under the frame that I propose, providing international assistance to Sweden to protect Syrian refugees would not be a priority because Sweden has the resources right now to protect the population that it has. On the other hand, countries like Lebanon and Jordan that have made explicit a lack of resources, given the sheer volume of the refugees, it would be a different case there, and the international community would then have a correspondingly higher, the nature and the extent of the responsibilities that are owed to Syrian refugees in Lebanon would be much higher than ones in Sweden, for example. And I'll talk about what concretely what steps the international community would take under responsibility to protect to fulfill the responsibility that I'm talking about. But I just want to make clear that one of the key moves that I'm making in this piece is to say that crossing borders doesn't sever international responsibility. Rather, the responsibility is going to track this vulnerability, and it's going to be a function of the host state's capacity to protect the refugees. And for as long as refugees don't have citizenship in their host nations, they remain at risk of being returned to Syria. So in very concrete ways, they remain at risk of R2P crimes. And for this reason, the international community does bear this continuing international responsibility to protect. So I want to make clear here that I see no place for coercive measures under the responsibility to protect having any place in refugee cost sharing or responsibility sharing. And in general, I'm very skeptical of military intervention and coercive measures against states for the protection of vulnerable populations from human rights violations. And that's a bigger topic, and I think there's gray areas, and it's possible to justify cases or to find cases where foreign military intervention might be justified. I think they're few and far between. But in the context of refugee protection, I make very explicit in my own work that I don't see there ever being a basis or a justification for any kind of humanitarian intervention, of any kind of military intervention. And it's just because of, if you look at the way that refugee protection works, typically when a state doesn't have the capacity to protect refugees, it seeks assistance, right? So one example you might think of is Turkey, for example. At the beginning of the Syrian refugee crisis, Turkey was reluctant to get assistance from the international community and was prepared to deal with protecting refugees on its own terms. As the crisis became bigger, it's been more and more open to international assistance. If you look at the 5 countries now who are hosting the most Syrian refugees, they've been very explicit about their need for assistance. So it would be strange, and I have trouble thinking about a situation where it would be necessary to use military force against a country that's hosting refugees in order to provide assistance to those refugees. So I make it clear that I don't see a place for coercive measures in the framework that I'm proposing. So moving on to what this whole regime would look like that I'm proposing. I'm just going to outline a little bit how I see R2P-based international cost sharing, what it might look like in real terms. So in international refugee law, and just historically, there has been the establishment of what are called comprehensive plans of actions. There have been a number of them to respond to various refugee crises, and essentially a comprehensive plan of action is a platform that's developed by key international refugee and humanitarian actors in collaboration with states to provide a comprehensive response to a refugee crisis. So there's been a number of these, and what I argue is that the responsibility to protect could serve as a basis for establishing a comprehensive plan of action to address the Syrian refugee crisis and other refugee crises in the future and even in the present that implicate the responsibility to protect. In my proposal, I say that the UN Refugee Agency would work in collaboration with host governments to make the case or to trigger a comprehensive plan of action. They would be the determiners of whether a comprehensive plan of action would be needed. And the comprehensive plan of action would serve as a platform for coordinating the refugee protection effort, and also a platform for determining what the needs of the various host countries are or would be in terms of assistance from the international community. And in the paper, I discuss some of the factors that international relations scholars have highlighted as being factors that make comprehensive plans of actions likely to be more successful. And I think in establishing a comprehensive plan of action, for example, for the Syrian refugee crisis, there is a literature and the experience to draw from that would help guide us, get a sense for what might make it successful and what might make it not quite successful. Through the comprehensive plan of action, I would say that there's 3 areas that the international community would be focusing on assisting hosts in terms of protection of the refugees, and these 3 types of assistance track the assistance that the UN Refugee Agency has identified in the Syrian Regional Refugee Response Plan as being priorities. And these are protection assistance, which goes to just legal status, ensuring that refugees have some forms of legal protection in whatever host countries they are. Tied protection assistance would be resettlement, and resettlement involves other countries beyond the region resettling refugees in order to relieve pressure within the region. And resettlement is not without its problems. It is a very complicated strategy or approach to refugee protection, but it's nonetheless one that is a necessary one. Separate from protection assistance, you would also have humanitarian assistance, and this would just be funding and to provide for the needs of refugees in terms of food, shelter, healthcare, and then development assistance to host countries. And for protracted refugee situations, I think development assistance becomes increasingly important. And I'm not the only one to say this, but development assistance in terms of helping host states maintain and expand infrastructure in order to be able to protect refugees and also their host communities, because you can't really think about the needs of refugees as separate or severable from the needs of the communities that are hosting them. So if you were to have this comprehensive plan of action under the responsibility to protect for Syrian refugees, for example, I propose that you would have to have common but differentiated responsibility among members of the international community, and here I'm talking about states. So that states would be required to contribute to this protection effort, and their contribution, however, would be determined by their capacity to pay. So a country like the Democratic Republic of Congo would not be required to contribute as much as a country like Germany, just in terms of the resources they have available. And so there's different ways you might calculate what the capacity to pay looks like. One proposal might be using the formula that's used for UN-assessed contributions, for example, which tries to take into account this precise kind of calculation, which is how much do states, what kinds of resources do they have, and based on those resources, what requests can they make. I also propose that there would be an offset for countries that are already hosting huge refugee populations. So you can't expect a country like, say, the countries surrounding the Central African Republic that are hosting refugees from that crisis to be able to resettle as many refugees as a country that is relatively resettling fewer or hosting fewer refugees. And so it would be a complex calculus, and in my paper I don't go into the details of exactly what that would look like, primarily because the key thing I'm focusing on is arguing that this frame of the responsibility to protect can serve as a basis for a comprehensive plan of action. And in terms of the details of what the comprehensive plan of action would look like, that's something else that would require lots of fleshing out and a lot of work. One way in which I see the responsibility to protect interacting with the comprehensive plan of action is that you could imagine the Security Council using its Chapter 7 powers to convene a comprehensive plan of action under the responsibility to protect. So Chapter 7 of the UN Security Council allows resolutions under Chapter 7 of the UN Charter are legally binding on UN member states, and so that might be one way to get some kind of legally binding CPA. And again, I want to make clear that just because we're invoking Chapter 7 here, this is not a kind of slippery slope into the use of force. And we could talk a little bit about why I don't think it has to go there in Q&A. So in the 5 minutes I have remaining, I want to talk briefly about what I think are some of the key challenges that have been raised against the responsibility to protect, and why I think the refugee protection context is different in terms of those challenges. So you have two camps. I identified two main camps that I think have leveled the most compelling criticisms of the responsibility to protect. There's critical scholars, critical skeptics, who basically said, look, the responsibility to protect is like a Trojan horse. It's actually a vehicle through which powerful states from the West can subordinate the sovereignty of weaker states to advance the interests of these powerful states at the expense of vulnerable populations in those countries. And so if you look at what happened with the NATO intervention in Libya, I think the concerns of critical skeptics are vindicated, because there you have an intervention that for the most part was devastating from the perspective of Libyans themselves, and different scholars have mapped out how various members of the international community have profited from that intervention, and even if they haven't profited, have sort of, washed their hands of it and left it to devolve into a situation that is most harmful for the very population on whose behalf intervention was justified. And then you have realist skeptics who said, well, they're also concerned with power, but they just view the responsibility to protect as, it only works when powerful states have an interest in pursuing the responsibility to protect. This is related to the critical skeptics, but where the critical skeptics are concerned with R2P as a dangerous ideological vehicle, the realists are concerned with R2P as just useless, ineffective. It's not reliable for pursuing any kind of international cooperation. So I think those concerns are valid, but I think that the refugee protection provides a different context that actually permits us to circumvent both of those criticisms. So if you think about the first one, which is this idea of R2P as weakening state sovereignty and also as harming vulnerable populations, if, as I do, you cabin the use of force, and I think you can do that successfully, then those concerns in many ways fall away. And if you look at what refugee cost sharing actually entails concretely, it's to my mind a redistribution of material resources from wealthy countries to less well-off countries, which are the ones that typically critical skeptics are concerned with. So if anything, in this way, the responsibility to protect might be used to strengthen the sovereignty of those states and to put them in a better position to protect refugee populations. So I don't see the same kinds of concerns that critical skeptics have leveled against the responsibility to protect in other contexts as necessarily applying to the refugee protection context. And where those dangers exist, they exist anyway, even without the responsibility to protect. So you can have military intervention without ever having the responsibility to protect. But Chapter 7 of the UN Security Council already establishes that. And so I don't see my proposal as creating new problems, but I see it as potentially solving problems that exist. And we can talk a little bit about that in Q&A, because typically I get pushback from critical scholars on this particular point. In terms of the realist critique of the responsibility to protect, I think that there is something to be said for framing refugee protection in a way that foregrounds the interests of states outside the region in refugee protection. And I think the Syrian refugee crisis really reveals how refugee protection isn't only important for the countries around Syria, but really it's a global issue now. I think the failure to cooperate to protect refugees has implications for regional stability, for international migration, for international security. And so in the framing of how refugee protection, cooperation to protect refugees and cost sharing is sought, I think there is a way in which those interests could be foregrounded in ways that actually facilitate cooperation. So I'm going to end now and just sum up by saying that I view a key challenge of overcoming this endemic maldistribution of refugee protection cost and responsibility in the international system as having in part to do with this absence of an institutional frame within which international actors can be encouraged or persuaded to provide, to cooperate to provide this protection. And the purpose of this project is really to argue that the responsibility to protect can be a frame for doing so, and that we should explore it because it could take us further than we've been able to go with existing international refugee law. So I will stop there.
Thank you very much for this very interesting lecture. Before we head out to Q&A, I'd like to, the Refugee Research Program at the Issam Fares Institute for Public Policy and International Affairs would like to thank you for coming to this lecture. To recap, I mean, a lot of the things that you mentioned really hit home in terms of how Lebanon has been dealing with this refugee crisis, and particularly the issue of burden sharing. So over the past 2 or 3 years, we've seen countless Lebanese politicians who have been begging the international community for some sense of whether it's resources, whether it's at least any sort of support in terms of aiding with the massive influx that Lebanon has been dealing with. And this issue of the perceived sense of resource scarcity is something that developing countries are, I mean, they're very used to. Jill Loescher, in his book, Contracted Refugee Situations, speaks of how refugees to developing countries are perceived as indirect threats. So they're there to take their resources, to take their jobs, and this is what we're hearing in terms of the narratives that are coming out of Lebanon. I'd like to ask you, and I'll get the ball rolling with this question. I'm sure you've probably read Kagan, who talks about splitting responsibilities between the states and the international community, or the states and agencies such as the UN Refugee Agency, UNHCR. So he suggests that we should split responsibilities, particularly having to do with protection based on particular incentives. My question will probably be central on the Lebanese case. So as many of you might have heard, the Lebanese government has put in a lot of legal measures now to curb the influx of Syrian refugees into Lebanon. So over the past few days, we've had around probably 0 refugees come in. Now refugees have to come in, they have to ask for a visa. And there's also another policy that, that says that any refugee that returns to Syria will be stripped of their refugee status. My question would be, with your comprehensive plan, would there be some way, for example, states like Lebanon, who have already developed their own sense of what they believe refugee protection is, would that be able to fight it, or would it be too far for Lebanon, in this case, a country that has been dealing with this crisis now for going into its 5th year, and it's yet to consider it protracted? They still call the refugees nazihun, so displaced, rather than laji'un, which means refugees. Would this plan have to be tackled at the advent of any crisis, or would you see some sort of long-term implementation for it?
That's a great question, and I think one of the key ideas is my goal would be to institutionalize comprehensive plans of action. So already 5 years into it, I think this would be coming too late. Ideally, you would want to have a comprehensive plan of action to be ahead of the curve, which is tricky because you don't always know when a refugee crisis is going to become protracted. I remember when I started working on this project in 2012, I wasn't even sure if I could use the Syrian refugee crisis as a case study because there was this sense that, you know, by the end of 2012 everything would be fine and we would have moved on. And now, of course, it's clear that that's not the case that we're in. So there is that particular issue. But I think ideally the idea is you would have a comprehensive plan of action before you are in a crisis that is this deep. And a comprehensive plan of action, it's a process. And the idea is that the countries that are the most impacted, like Lebanon, like Turkey, would be key actors in developing with the UN Refugee Agency and other members of the international community what protection would look like. And so the challenge and also the benefits of a comprehensive plan of action is that it can diverge from international refugee law. A country like Lebanon, for example, that isn't bound by international refugee law there wouldn't be a legal basis for holding it to the kinds of standards as, say, Egypt, which is. But the idea is this comprehensive plan of action would have to stipulate, the maximum amount of refugees that the that Lebanon would have to host, where the surplus would go, what kind of funding Lebanon would be entitled to in order to protect refugees that are in its territory. And I mean, one of the challenges is because my project is so kind of macro level focused, it completely elides the kinds of violations that hosts themselves may perpetrate against refugees, and that's a huge issue. But I think by establishing a framework that has this idea of refugee protection and cost sharing as the baseline, advocates then have a way of holding states accountable to various promises they've made. So, for example, if in the comprehensive plan of action, Lebanon had committed to hosting 500,000 refugees, and the U.S. had agreed to take on, I don't know, say 40,000. If there were violations of those terms, then advocates in the Lebanese context could use that as a basis for advocacy to see some kind of change. So, again, the details require more fleshing out, but in general, that's the kind of situation that I would see.
Thank you very much. We have Dr. Azam at the back, and then Roland.
Thank you very much, Tendayi. I have a couple of thoughts. One that's been bothering me for years on the issue of refugee protection. You dealt with it a bit in terms of definitions. I've never quite understood what refugee protection really means in international law. In dealing with your definitions, you talked a bit about humanitarian assistance and you talked a bit about development assistance, but we never really have a clear definition of what's protection assistance. What is protection? When you look at the way UNHCR deals with refugees all around the world, what they refer to as protection is in fact assistance. It's provision of food, of aid, basically protecting them from dying or from freezing or, you know, along those lines, but not really protection with any kind of a concept of protection from serious harm, protection from R2P crimes. None of that is on the books in terms of UN and other agencies' mandates. So if you can unpack that a little bit, I'd be very interested in hearing your thoughts on that. The other thought I had is on the comprehensive plans of action. Wouldn't you say that that already takes place at the very least in terms of, maybe it goes back to the definitions, in terms of assistance? When you have the Office of the Coordinator for Humanitarian Affairs, OCHA, that always kicks in, and it has kicked in the Syrian crisis, and it brings together all of the agencies, you know, UNHCR and UNICEF and the World Food Programme and everybody else that gets involved in humanitarian assistance, and they put together a kind of a plan of action, the basis of which they issue these calls for assistance. I forget, there's actually a name for it, you know, where they issue kind of a UN-wide call for assistance, and that you referred to it earlier in your talk about, you know, they only have been able to get 40 to 60% of. But that is a plan of action of sorts, isn't it?
Mm-hmm.
Thank you.
Would you prefer to take a few questions and then reply? Or?
Since that's a few questions, I'll take those too.
Okay.
But I think you're right, taking a number is useful. So if the next one is 1, then we could take...
We have 2. So we'll go to Roland, then we'll go to...
I think it's kind of related, my question to Dr. Issam. Yeah. Well, in fact, Lebanon, like Rima was saying, they were expecting having money from international organizations. And I remember in a year and a half after the Syrian crisis, the World Bank issued a report with Lebanon, the cost of the crisis would be like 7.5 billion, which is like Lebanon missing a growth of 25%, which is a bit abnormal. And Lebanon kept on having a growth normally. So asking for such amounts refers also refers on somehow how would it be the process of asking those material resources from the international community, having beggars, as Rima was saying, like Lebanese officials are, and with the World Bank, seems to be overestimating the amounts. So how would be what would be the actors, how would be this comprehensive plan of action would be dealing with financial issues? It's not, okay, the financial, they do exist, they are here, but how to assess them and how to evaluate them? Thank you.
I have a couple of comments, half questions. And as a hardline refugee practitioner myself, I like schemes, but I have a funny, not schemes, what you call them, frames. Mm-hmm. But I have a bit of a difficult relationship with frames. You know, I remember, I've left UNHCR now for many years, but one of the points that was often made by protection colleagues was, yes, the refugee protection regime needs expansion, updating, definitely, we all agree. Mm-hmm. But be careful what you wish for, because if you go to the political table and renegotiate a refugee protection regime, you risk getting less rather than more, given the political attitudes towards asylum, migrants, and so forth. That's my first question. You know, I'd like your views on that. The second is, I do understand, I think it's interesting that you resort to R2P to promote your argument on CPA, on comprehensive plan of action as a kind of frame for refugee for improved refugee protection. But why R2P? You yourself said that it's a, you know, when people think of R2P as its third pillar, always, and it is polarizing. Politically, it is limited in definition. You said these things yourself, and may I said it has spectacularly failed, either when it has happened in Libya or in Iraq, or where it has not happened, like in Syria or in Gaza, for example. My third point, you don't need to reply to all, but you know, pick and choose. My third point is more specific. What I didn't really understand, and maybe I'm with Fateh on this. What are really the components of the CPA that you are proposing that are not already, I would even say, promoted by UNHCR? You know, more resettlement to third countries, more money for assistance, and better legal instruments. You know, you mentioned those three, of course, but these are things that UNHCR already everywhere demands. I guess, if I interpret correctly, what you're suggesting is a more compulsory frame that obliges states to participate in all three in a manner that is similar, say, to assess contribution. I would say there I would be a little bit in the realist camp. You know, the trend is more to go to voluntary contribution in all these areas rather than the opposite. And having worked all my life in organization dependent on voluntary contribution, I know that this is an uphill battle, and I don't know if it has any chance to be solved. I just want to conclude with a small, in fact, something in response to what Fateh said. I would not agree that international protection is just assistance. UNHCR, for example, promotes the right to asylum, the right to open borders. These are not assistance measures. These are international protection measures, among others. So I think it's already a more nuanced picture than just material assistance. Thank you. But thank you for your interesting exposition.
Okay, so this is why I should have spoken for 15 minutes and did Q&A for an hour and 20, because I think these are all really interesting questions that get at the heart of the project and the problems. And I won't have satisfactory answers for all of them, but I definitely want to share my thinking about, and most of everything that you're raising are things that I've been concerned with as well. So starting just in the order that I received the questions. Fatah, your question about what does refugee protection mean, or what does protection mean in the refugee context? Thank you for beginning to answer the question for me. I think the question of what protection means can be addressed at multiple levels, right? So there's the legal question of what is protection, and I think as you mentioned, the UN Refugee Agency has done some work to lay out what that means, right? So legal status, documentation, all of this sorts of thing. But I think there's a deeper challenge in your question is what does it really mean for a refugee on the ground, right? What does protection, the lived experience of protection mean, and what are the limits of that concept in terms of shaping the way that refugees live their lives? I think that's a really deep problem, and I don't have an easy solution for that. If I did, I wouldn't be here. I would be leading some organization and healing world peace. But I think what I'm doing in this project is straddling a kind of a regime complex, right? So you have international refugee law, you have international humanitarian law, you have international human rights law, and I think all of these bodies of law have different concepts of what protection means. And the responsibility to protect I see as a very malleable place where you can have contestation about what protection might mean in different contexts concretely. Right now, as I said, the conversation has really been stuck in this kind of military force way, and part of this project is trying to push us beyond this to kind of see what protection might mean. And countries like Brazil, for example, I think have been invested in this, who've talked about the responsibility while protecting. There's people who've talked about the responsibility to rebuild. And I think these are all efforts to really deepen what protection means from the perspective, I guess there it would be humanitarian law. And so what I'm looking for is ways in which the international legal framework or the international normative framework can provide hooks for domestic advocates to give the word protection meaning in concrete context. So this is a very abstract response, but I remember from my days as a refugee protection lawyer, you take what the document says on a piece of paper, you look at the situation confronting the person in front of you, and you see how best you can meet their needs given what the law says. So I think in the paper, which I'm going to make you read whether you like it or not, I try and spell out in more detail what protection assistance means, what humanitarian assistance means, what development assistance means. And yes, much of it tracks what UNHCR has said, and in addition to that, I kind of draw from other scholars like Omar Dahi, for example, who's written about what economic assistance to Lebanon might look like on behalf of Syrian refugees. I think that kind of fleshing out is really, really important. So that's just that. On the question of, okay, we have a CPA, it already exists. If you look at what UNHCR is doing, this kind of goes to your comment as well. I would say yes and no. I think in terms of the concrete action that is required, or if you think of a CPA as an operational plan, yes, what I'm proposing already exists. The Syrian Refugee Response Platform is very much what I draw on, and there's a document that has a very kind of well thought through, if you ask me, sense of what needs to happen. What's missing, though, is I think that it's often a conversation that's happening among the different UN refugee agencies and then the host community, and the rest of the world gets to kind of be left out of the conversation. And what I see the responsibility to protect doing is shifting the existing CPAs we have from being an issue that the UN and the 5 countries in the region need to be concerned about to becoming one that is a concern of the entire international community, or at least key stakeholders. And I think this is what's been different from, this is what Okay. This is what differentiates, for example, the CPA that was established following in the 70s in the Indo-Chinese region, for example, where you had buy-in of key political actors. There was a long process to kind of get that political buy-in. That's what's missing, I think, from the CPA. One of the things that's missing from the CPA, you might say, that already exists in the context of the Syrian region. Now, it takes a lot of work to get to that point where you have this political buy-in. It takes a lot of work before you even get to the CPA. But I think by using the responsibility to protect, you set up a framework that makes it automatic that the international community from the beginning is invested, not just when it's time to raise money, but even before, in just acknowledging the problem and framing it, you have that buy-in. So that's what I'm trying to do by locating the CPA within R2P. Whether or not it'll be successful, I think, depends on what happens on the ground. But I think just at a theoretical or as a normative matter, I think that shift is very important. So the questions you raise also, I think, are really valid. So oversight, for example, what kinds of incentives are there for states in engaging in this process? Are there going to be states that overestimate or underestimate the resources? How will these resources be used? And even once you have the money, is it going to the right people for the right purposes? I think those are very real challenges, and we would have to look at. So in terms of accountability, I see there being a kind of side-by-side process where you have the UN Refugee Agency, which is not a perfect institution by any means, but does have a lot of technical expertise, and I think also legitimacy in the eyes of many actors in the international community. If the determination of what the contents of the CPA were jointly agreed to by host nations and the UN Refugee Agency, I see the UN as kind of playing that checking role. In terms of implementation, once the resources are available, we would have to draw on successes and failures from past experiences. And this is one thing that I try and foreground in my own work, is that, you know, international lawyers who are thinking about coming up with these plans need to look to see what international relations scholars, economists, and all these other people have been saying about when plans work and when they don't. And I think that experience would have to feed into the kinds of, you know, micro-level institutional moves we make to realize the plan that I'm advancing. Renegotiating refugee protection and this idea that we have to be careful because we might, I think you're absolutely right. This is the danger. And so I don't even know if we could get all the states together to renegotiate, but let's say we could. I think you're right that we might get even worse than we have right now. And this to me is one of the exciting things about the responsibility to protect. It doesn't really require a reconvening, and I think any gains or losses that are made within the responsibility to protect do not have to detract from international refugee law as it exists. And so I see this as circumventing exactly that issue, while nonetheless presenting a possibility that we might get more than we have now, because you would be able to engage countries that aren't bound by the Refugee Convention. You might get countries that are bound by the Refugee Convention to do more than the Refugee Convention requires. You may not, but if you don't, we're not worse off than we are now. So even though this is kind of the third best response, I don't see this proposal taking us to a worse place than we are right now, but I do see potential that it could take us somewhere else. Now, in terms of why R2P and hasn't it failed, and this is something that I've been thinking a lot about. I think to say R2P has failed is to say that it has failed to guarantee international cooperation to take coercive action against different states. And when coercive action has taken, it's been a very messy situation. So I concede that failure, and I think what we learn from that is that the responsibility to protect likely isn't at its best when it's all about foreign military intervention. And so I concede that. What I'm interested in is whether we can focus on everything else that R2P might offer. And I think there hasn't been enough investment in the non-military intervention elements of R2P for us to really know whether it will succeed or fail. Now, some people argue that you can't have it one way. If you're talking about, you know, refugee protection and humanitarian humanitarian assistance, you're just a step away from foreign military intervention. And so by using R2P, you can't get away from that. But I actually don't think that's the case. I think for as long as you have countries like Russia and China on the Security Council vetoing any coercive use of the responsibility to protect, it's possible that those very actors might nonetheless cooperate in ways that aren't about coercive measures. And if you look at Security Council resolutions and the kind of the debates that have gone on there, there is a willingness, I think, among those countries to consider alternative ways of using the responsibility to protect. And some people may reject that, but we could talk a little bit more about that. In terms of why I'm personally invested in the responsibility to protect, this is now me kind of wearing my scholar's hat and less my kind of refugee protection oriented act. If you look at middle powers like the BRICS, or even just IBSA, India, Brazil, South Africa, these countries have been, I think, doing a really interesting job of articulating a different vision of what international law can look like. And one of the forums, or one of the frameworks within which they've done that, is the responsibility to protect. And so I see this as being a doctrine that could possibly be co-opted to shift the international legal frame or the international legal order in a direction that resonates more with their interests. And these are countries that have resisted military intervention on the basis of the responsibility to protect, but nonetheless have been willing to support other ways of thinking about the responsibility to protect. So this is why I think this is a doctrine that might actually be interested. And these are the countries that I think stand to gain the most if this approach works. And I think also something interesting comes out of this. If powerful countries are not interested in this use of the responsibility to protect, what we learn is the critical skeptics are actually right. This is just a, you know, neo-imperial wolf in sheep's clothing, and we should just get rid of it. I think we get more information. So I see that as another bonus. So I think, and then you asked about the CPA, how is it different? I think I responded in Fatah's comment.
Thank you. Any additional questions? Haya at the back.
First of all, thanks a lot for the really interesting lecture. Speaking of coordination and cooperation between countries, I'd like to talk about the, I don't know if you heard about the whole of Syria meeting that took place by end of January. It was headed by OCHA, and the main aim of this meeting was to create a mechanism of coordination among all agencies who are providing aid to Syrian refugees. And I was present at that meeting, and the main concern was that there is no political will from donors to commit to their pledges. I mean, if they pledge to give these millions or billions of dollars, there's no political will of them to commit. And other thing, which is related to when you spoke of development assistance, that's important for host communities and for refugees alike, because we are suffering now from protracted conflict. Even the donors, they are rejecting to give funding for development projects. So the whole Syria aid now is concentrated on emergency aid, and now we're entering the fourth year, and it's still emergency. I mean, this is absurd. So, I mean, what can the whole international refugee law or all the conventions that are taking place now in the UN do when we do not have a political will?
Yeah.
Thank you.
Any final questions? Okay, we'll leave that last interesting.
Okay, and that's like the subject of a book. So, I mean, you're absolutely right. I think you're getting to the core issue. It is one about political will, and you know, you can have a frame, but if you have no political will, you're not going to get anywhere. My response to that is I really see frames as being about helping us gain traction on political will. And this goes back to different understandings of how it is that we can get states to behave in different ways. So I happen to subscribe to this idea that in order to change state behavior, one particularly powerful way is to get domestic constituencies involved in what it is their countries are doing abroad. Right now, if you look at the way the conversation about protection of Syrian refugees is playing out in the media outside of the region, and this is what I'm most exposed to. There is very little discussion of the Syrian refugee crisis in the media. Every once in a while, maybe the New York Times will have an article. It's getting a little bit better. But it's really off of people's radar, right? And so I think what's necessary in order to get political will is to put the Syrian refugee crisis onto the agenda of especially wealthy states as a priority that they absolutely have to take seriously. Part of that, I think, is the branding of the crisis, to put it very crudely, right? And I think the responsibility to protect may provide a vocabulary for advocates, say, domestically in other parts of the world who are interested in seeing their countries do something differently, to be able to get their states to do so. So I'm not being very articulate about this, but essentially what I'm saying is I think that having a frame like the responsibility to protect may shift the calculations that states are making and may shift the political will that they have to deal with this issue, because for different reasons it puts states that have publicly stated their commitment to protecting vulnerable populations, to protecting refugees in the abstract, on the spot for actually doing so. Right now the discourse is one of charity and international solidarity, and the thing about that, it's really difficult to hold people accountable to an amorphous sense of charity or international solidarity. Now, yes, even when you have binding laws, it can be difficult to hold states accountable to that, but it's easier to have an accounting of what they're supposed to do, how much they haven't done, what you're requiring them to do, and then kind of have that frame for pushing political will in that direction. So I see this proposal as making more concrete the parameters within which we might seek that political will. We may not get there 100%, but I think it'll definitely be a step in the right direction. And, you know, so for example, all of the fundraising meetings that the UN has coordinated, that Kuwait has hosted, again, outside of the region and outside of people like you and me who follow refugee issues, people are just not talking about this. Whereas when you had the Libyan intervention, for example, the responsibility, it was in the media. So some of this stuff is just, how do you get more people concerned about this issue, and how do you establish guidelines or standards to which states can be held accountable by the various actors who do that kind of work?
Thank you very much, Tendayi, for this brilliant lecture again.
Thank you, all of you. And again, as I said, if anyone is interested in reading the paper and giving me feedback on it, especially this kind of really hard, challenging feedback, I would be more than happy to send it to you.
Thank you very much. On a final note, this lecture is audio taped and also recorded online if you'd like to revisit it. Also, please visit our IFI website for updates on our various projects and our upcoming lectures. Thank you very much.